Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Where are we today? Come on. We're at the hometown of America's hardest working rock and roll band, the one, the only Cheap Trick, right here in Rockford, Illinois. Hey, speaking of cheap tricks, I want to talk about another cheap trick that's actually being played on a lot of voters in a lot of states by a bunch of attorneys generals. Yet it seems like a whole bunch of them are out there bragging about a big win that they got, when in fact they didn't win a darn thing. Don't believe me? We'll explain it all in just a moment. So today, from Rockford, Illinois, let's spend a few minutes and let's talk about the AG's taking a victory lap after winning nothing. Okay, America, here's what we're talking about today. We are talking about the forced reset trigger settlement one more time. But in particular, what we're going to be talking about is a purported lawsuit that was filed by numerous attorneys generals, most of which come from the states that we like to call the Dirty Dozen or the usual suspects. And now we're seeing a whole slew of them puff their chest out, pat themselves on the back, talking about how they won a huge victory because they're going to keep the Trump administration, that's right, they're going to keep the Trump administration from allowing machine gun converting devices back into their states. But here's the reality of the situation. As we know, the settlement agreement was reached between NAGR and Department of Justice. Amongst that was an agreement that there would be a return of triggers. On June 9th, as ATF was actually publishing the protocols and procedures for the return of the triggers, these attorneys generals all filed suit in the District of Maryland. Wonder why they chose that. However, less than 24 hours after the attorneys generals filed the suit, ATF updated the return procedure and policy to read as follows. Some states independently prohibit the possession of forced reset triggers or trigger activating devices. If you live in a jurisdiction in which the possession of a forced reset trigger is prohibited by law, ATF will work with you to return the device in a place where it may be lawfully possessed, or upon request, will transfer the device to a third party who may lawfully receive it. Now, what these attorneys generals don't want to tell you is that they actually had to have oral argument on this case, and during that time they tried to actually drag both Rare Breed and NAGR back into it. The court made it very, very clear that they lacked standing to even challenge anything that Rare Breed or NAGR had done, and they were summarily dismissed from the suit. The court ultimately hinted to all of these attorneys generals that, you're lacking standing here whatsoever. You really don't have a claim whatsoever. And we do believe at this point that a motion to dismiss that lawsuit is forthcoming from all the attorneys generals. But while they sit there and they claim that, hey, we won this big lawsuit, we're going to keep the ATF from returning machine guns into our jurisdictions, the truth of the matter is, everyone, and I was privy to some of these conversations, the fact that some of these triggers were going to go back to individuals where in the interim between Operation Reticent Recall and the time the triggers are going to be returned, their states had passed laws banning those types of devices was always in discussion and was never going to occur. The ATF and the Department of Justice had made it very clear to all the parties that were negotiating this settlement that under no circumstances were they going to return any device which would be in violation of state law. That was always part of the negotiations. That was always part of the settlement agreement. That was certainly part of the understanding of the settlement agreement, and the exact reason why ATF published it on their website the very next day after this suit dropped. So at the end of the day, for the Matthew Platkins and the Rob Bontas and the Kwame Raouls out there who are all running around patting themselves on the back that they won some huge lawsuit, the truth of the matter is they're all taking a victory lap for something that they never even won. Listen, we'll go ahead and link up information relevant to this story down below in the description box so you don't have to take our word for it. If you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington Gun Law by now, but if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, that information is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. From Rockford, Illinois, thanks for watching and stay safe. they're saying, you know, what happens is these people get involved in these situations and then they're just denied coverage.
Yeah.
And I think that the model of what some of these companies run, as far as they run like insurance companies, actually leads to that result a little bit. But, you know, that's a fair criticism. People are going to invest money and you're going to be there when it hits the fan, and then it hits the fan and you're not there anymore. What can Right to Bear say that's going to make them different?
Well, yeah, I think that's a great point. You know, I come from the insurance industry, so I know it well. I know that insurance contracts are written by attorneys for the benefit of the insurance company, not the insured.
That's right.
So what we did at Right to Bear is, you know, we're first off, we're gun people that are in the business of supporting gun people. When we started the company, we knew of the numerous other players that had this market pretty captivated at the moment. And after reading their contracts of everybody, we determined that, hey, we can structure an arrangement that gives people and really the citizens of our country somebody that's going to be there when they need us most. That was what we prided ourselves on, and I know that sounds like a marketing piece, but it's the truth. That's why we started the business, right?
You're not truly prepared unless you have Right to Bear back you. You will always get an attorney-answered hotline, so you will always have a confidential phone call. There are no cap limits for either civil or criminal defense. This covers all forms of self-defense. So from a fist to a firearm, from a fat lip to a dead body, you are covered, and you will have some of the nation's most passionate 2A attorneys in your corner fighting for you. And right now, if you visit my friends at protectwithbear.com and you use the promo code WGL, you will receive 10% off. Listen, you need to protect yourself so that you can protect them. Visit my good friends at protectwithbear.com.